Somebody asked yesterday on the YouTube chats just for an update on cases concerning gun bans and other gun control measures and where we're at in the courts with all of these things. Figured I would kind of break down where we are with all of these things, because really, we're kind of in a holding pattern. At least when it comes to challenging Illinois' gun and magazine ban. Welcome back, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Program notes, I am off tomorrow, so there won't be a live show. Just want to make sure you guys are aware of that. If you're looking for any new content, we will have at least one or two segments that are new based off stuff happening today, but I won't be here on the program live tomorrow, Friday, so just a heads up on that. But let's get to the latest in gun litigation. Of course, we've been tracking this really since before Governor J.B. Pritzker enacted the ban on semi-automatic weapons and magazines over certain capacities. And you've got cases in both federal court in the Seventh Circuit Court of Appeals, and you've also got a case that's in the Illinois Supreme Court. But there are other cases as well dealing with gun laws, like challenges to the Firearm Owner Identification Card Act. So we'll touch on some of those, and this is not going to be a complete list of all of the challenges there are, but at least some of the ones that we have on our radar that we've been watching. So I want to get you guys updated on all of that. So let's start with the state level cases. All right. So you've got the Illinois Supreme Court that, months ago, seems like now, they heard the case that was brought by State Representative Dan Calkins. And if we look at the docket, there's not much action there. You've got the Illinois Supreme Court really not moving on it. All of the filings are there from the Supreme Court's website, Dan Calkins et al. Versus the governor and others. And this was a case that was filed in Macon County. And you had a judge ultimately say that, it's unconstitutional. Now, whether or not that led to a temporary restraining order statewide, that was disputed by the Attorney General's office, but still obviously something that's very much in contention as to the case that's now in front of the Illinois Supreme Court. Now, you do have temporary restraining orders in state court protecting thousands of individuals, including Dan Calkins, and including the cases that Thomas DeVore brought in multiple counties. And those are still down in those multiple county courts dealing with a variety of things, but temporary restraining orders in place protecting thousands of people from having the Protect Illinois Communities Act being enforced against them. That's on the state level side. So we still don't know when the Illinois Supreme Court is going to announce any kind of decision. They do have a website, anticipated filing dates and opinion list. And the most recent anticipated opinion date was Thursday, June 15th. So we're talking about nearly a month ago, and they have yet to reveal if they're going to release any other opinions in the near future. So again, that's the state level case concerning the challenge that State Representative Dan Calkins brought against the state's gun and magazine ban. Let's look at some other state level cases, not necessarily dealing with the state's gun and magazine ban, but in particular dealing with maybe the FOID Card Act. And you've got cases that have been filed in various circuit courts across the state dealing with that. And let's check out the latest when it comes to a case that was brought forward by Thomas Mag. He of course is a lawyer for the plaintiffs in the Seventh Circuit Court of Appeals case. He was the first to challenge Illinois' gun and magazine ban in Crawford County Court. That was transferred to federal court. But Mag has other cases where he's the lead attorney dealing with challenges to Illinois' FOID card. And in this case, we'll check out what GunSaveLife.com has to say here. And they've got, just an overview of the latest filings in a case challenging the FOID card. And if you remember, this case dealt with a couple of individuals who had their FOID cards suspended for charges they faced. And those charges were ultimately downgraded and they weren't felonies. So since they weren't convicted of a felony, they should get their FOID card restored, and it should have never been revoked. Well, the challenge here led to a judge essentially saying that you can't do that. The judge ultimately filing their order, and you can see the order here saying that, yeah, indeed, you can't suspend somebody's FOID card unless they are charged and convicted. You can't just suspend it based on an arrest. So the latest in that case is that Kwame Raoul and the Attorney General's office, just before the deadline to appeal, the Attorney General filed that motion with the Illinois Supreme Court, appealing the Madison Court's judge's ruling on March 10th. So we'll likely see that case, obviously, in the Illinois Supreme Court, and we'll be watching to see when the Illinois Supreme Court puts this case on their high-profile case list, which you've got a list already growing of different high-profile cases that the Illinois Supreme Court has in hand. So another case that's up for consideration is in Sangamon County, and we talked about this. This challenges the FOID card as well, and you'll see that obviously on June 20th, they had a hearing in this case, and the various parties were ordered to submit some proposed orders within 21 days of the case being heard. Well, here we are now. We're I think around a little over 21 days from when that case was actually heard. And you got to expect those orders, those proposed orders, were filed with the Sangamon County judge in that case, challenging Illinois' FOID card based off of the Bruin decision. And obviously, that's something that's been argued in the circuit courts. Whatever the outcome is there, you can expect it'll likely be appealed to the state appellate court. And who knows, maybe that will also get up to the Illinois Supreme Court. But the Illinois Supreme Court really hasn't been too reticent to deal with some of these challenges of the FOID card, let alone of the various cases that are brought forward challenging the gun and magazine ban. Another case that Thomas Magg has in state-level court deals with the FOID card, and it's a case that he has on behalf of Gary Myers down in Madison County. And I'm pulling up the docket here just to show you where we're at with this case. And this case also deals with challenging the FOID card statute, in that the plaintiff in this case had a prior conviction of cannabis. It was a nonviolent conviction years ago, but he was kept from getting a FOID card. And then you've got the lawsuit being filed. But this is what's interesting about this case from Thomas Magg, is this is challenging the FOID card is count one, but it also, count two, challenges that state law that Governor J.B. Pritzker signed that limits the venue of where people can file constitutional challenges against the government. And if you recall, we've talked about that a lot too. The law that the governor signed says you can only challenge state laws on constitutional grounds in state court in either Cook County up in Chicago or Sangamon County in Springfield. And those are the only two counties out of 102 counties in the states that you're able to file a lawsuit. Well, Magg didn't follow that, and he went ahead and filed this case challenging the FOID card on constitutional grounds, but also challenging this law limiting the venue where people can file lawsuits. So let's look at the docket entry here from the Madison County courts. And you can see, the case was filed June 7th. It's against Brendan Kelly from the Illinois State Police. You've got various motions and so on. But here you've also got the latest entry is that proof of service has been made against Brendan Kelly. So service of summons, and that was on the 26th. Have not seen any update on the docket here, but the complaint on Brendan Kelly, 626, has been served. So we'll see. And even Thomas Magg said that he challenges the Attorney General to try to remove that case from Madison County to Sangamon County, because obviously that'll spark the ongoing litigation about the law that limits the venue for where people can challenge state laws on constitutional grounds. So those are just some of the state-level cases. All right, we have yet to even get to the federal-level cases. And if we take a look at the Consolidated case that was brought by groups from the Southern District of Illinois, but also by groups from the Northern District of Illinois, those consolidated cases in the 7th Circuit Court of Appeals. And let's take a look at that docket, because it's kind of just holding there. We're in a holding pattern. We had that hearing. Let me make sure I've got this where we need it. Here we are. We had the hearing last month. And, of course, we've heard some of the arguments there, but the hearing happened. But the latest entry in this is that apparently there was a denial for reconsideration of a motion that was filed by a non-party. John Cutinelli looked for reconsideration of the denial of leave for an amicus brief, and they denied that. So they're not allowing this particular amicus brief to be filed, even though you have amicus briefs that were sought to be filed by a variety of other states, like the state of Alabama, the state of Arkansas, Alaska, Florida, the state of Idaho, looking to file those amicus briefs as well. But the judge, even the Seventh Circuit Court of Appeals, when they accepted this case, they even said that it was going to be on a rocket docket and they weren't going to accept appeals. So that case is still pending. We're in a holding pattern there. Who knows when the Seventh Circuit Court of Appeals is going to issue their opinion. The 3-judge panel on that case, and regardless of how that goes, it's expected to go to the U.S. Supreme Court. But there's also the case that McHenry County State's Attorney Pat Keneally brought against the gun and magazine ban on behalf of McHenry County residents. This was originally filed in McHenry County State Court, but now you've got it being transferred to federal court. That also is still just kind of hanging out there. Mid-May is when you had the last docket entry with the state filing various briefs and various exhibits in that case. So again, everything right now, we're in a holding pattern, and we're waiting to see where the challenge on the state ban and local bans goes in the Seventh Circuit Court of Appeals. We're waiting to see where the Illinois Supreme Court lands on the challenge of the gun and magazine ban, which the difference between the federal challenge and the state challenge is the federal challenge focuses on the Second Amendment arguments. The state challenge focuses on the equal protections arguments, and we have yet to see any litigation go through the process of challenging the gun and magazine ban on grounds of Fifth Amendment rights. Your right to not incriminate yourself, because the state ban requires a registry of firearms starting January 1st. If you had one of these banned firearms before the law was enacted January 10th. So while that has been filed in the original MAG case, the Fifth Amendment argument was not included in the consolidated cases that went up to the Seventh Circuit Court of Appeals. Will MAG bring out that Fifth Amendment argument in the lower district court for the federal government? We shall see. But one thing that we do want to check out is the case that MAG did bring. It's the Langley case. And let me just pull this up really quick, because I think it's important as well. But the Langley case was the case that MAG brought, and he actually went back and sought for a narrow ruling. All right, so let's see here what we've got. The motion for partial judgment, all right, on vagueness. And that was a motion that MAG made back May 19th. All right, so what do we got here? 629, motion for stay is granted in part from Stephen McGlynn. We'll have to take a look at that. So, let's notice of modification, docket entry. Let's open this back up, get some indication here. So, it is so ordered. What does he say here? Before the court is defendant Brendan Kelly to stay motion for summary judgment on April 28th, 2023. A notice of appeal regarding the court's order granting motion for preliminary injunction was filed. The interlocutory appeal pertains to the Second Amendment claims presented in this case and is currently pending before the Seventh Circuit Court of Appeals. This court has consolidated this case with the other cases for purpose of common claims and stayed litigation of other claims presented. Although the interlocutory appeal does not pertain to criminal enforcement of Protect Illinois Communities Act on vagueness grounds, as the Langley plaintiffs now raise, the appeal is fully briefed and argued and may impact enforcement of Protect Illinois Communities Act. Thus, the intent or the interest of judicial economy, the motion to stay in part consideration of the motion for summary judgment for 45 days. The courts will set this case for status conference at the end of the 45 days it is so ordered. So obviously something else that we'll have to keep a close eye on here as we continue to track the latest in all of the different litigation against gun control laws in the state of Illinois. In no way is that a comprehensive list, but hopefully that lets you know we're just kind of hanging out waiting, right? That's where we're at with all of this. So I appreciate your guys' attention on that.